We are now going to look at the themes of proactive intervention, attachment and timely decision making. As we go through these slides, you'll notice the provisions in the Act relating to these themes are strongly aligned with the Department's practice approach, solution-based casework. So Section 10, the principles of intervention, state that in each case, consideration should be given to making arrangements for the care of a child or young person by way of a family group conference, wherever possible and appropriate. Chapter 4, which deals with managing risks to children and young people within their home environment, provide for CFANs, for child and family assessment and referral networks, which allow for services to be provided to children and young people whilst they remain at home. Family group conferences are also provided for in Chapter 4. Family group conferences replace the existing family care meetings. They reposition these meetings as a decision-making forum between the department, the child and their family to make decisions relating to securing the safety of the child or young person, as well as arrangements for the child's placement and ongoing living arrangements. Unlike existing family care meetings, the new Child Safety Act provides that family group conferences can either be court-led or department-led. We'll provide more information at a later date relating to what those department-led family group conferences might look like. Section 34 deals with the Chief Executive investigating circumstances of a child or young person. This relates to the actions that the Chief Executive may take upon receiving a mandatory notification. However, it's important to note that this provision has been extended and also states that the Chief Executive may cause an investigation into the circumstances of a child or young person to be carried out in any other circumstances that the Chief Executive thinks appropriate. Let's now look at the placement principles under Section 11. The placement principles are as follows. All children and young people who have been removed from the care of a person under the Act should be placed in a safe, nurturing and secure environment. The preferred option in relation to such a placement of a child or young person is to place the child or young person with a person with whom they have an existing relationship. And approved carers are entitled to be and should be involved in decision-making relating to children and young people in their care. The Aboriginal and Torres Strait Islander placement principles are also carried over from the existing Children's Protection Act. Section 8, which we spoke about in an earlier session, relates to the needs of children and young people which need to be taken into account when making decisions in relation to the administration, operation and enforcement of the new Child Safety Act. One of these factors that needs to be taken into account is that in the administration, operation and enforcement of the Act, children and young persons' need for love and attachment must be considered, including, as you can see under Section 11, whether in the circumstances it is possible and appropriate to place a child with a member of their own family. Part 3 deals with the principles to be applied in the operation of the Act. Section 10 states that all decisions and actions made under this Act should be taken in a timely manner and in particular should be made as early as possible in the case of young children in order to promote permanence and stability. This focus on timely decision-making also applies to the courts. The Act states that before applying for a prescribed court order in relation to a child or young person, the Chief Executive must assess the likelihood of a reunification occurring. And if reunification is likely, the period in which reunification is likely to occur. Section 89 deals with certain approved carers being able to apply to the Chief Executive to seek a long-term guardianship order. This relates to what we now know as Other Person Guardianship, or OPG. Under the new laws, if a carer has been caring for a child or young person for at least 2 years, or a shorter period if allowed by the Chief Executive, that carer may apply to the Chief Executive for an application to be made in accordance with Section 91 of the Act for a court order placing the child or young person under the approved carer's guardianship. Once an application is made to the Chief Executive is then obliged to make an assessment as to the suitability of that carer to become the long-term guardian of the child. If the carer is assessed as suitable, the Chief Executive, in consultation with the carer and child or young person, must develop a long-term case plan in relation to the child or young person. Once that plan is developed, in a timely manner, the Chief Executive must apply to the court for an order to be made. Section 59 deals with the onus of an objector to prove an order should not be made. This relates to the onus of proof. Let's have a look at what this means. Upon an application to the court for orders relating to a child or young person who is, pursuant to an order of the court, under the guardianship or in the custody of a Chief Executive or another person or persons, if that person objects to the making of an order by the court, the onus is on that person to prove to the court that the order should not be made. It is important to recognise that this reversal of the onus of proof does not apply in situations where the person objecting to the making of the order is either the Crown, or if the court is satisfied that the child or young person to whom the proceedings relate is not being unduly influenced by another person to object to the making of the order, that child or young person. As we spoke about earlier, the principle of timeliness also applies to the court, and Section 56 relating to adjournments states that all proceedings under the Act must be dealt with expeditiously, with due regard given to the degree of urgency in each particular case. Additionally, once a trial under the Act commences, it should, as far as practicable, continue without adjournment until all evidence has been presented, and the judgment should be delivered as soon as practicable after all evidence has been presented.